So initially, I'll be making you aware about what FinPro is, and then we will go further on the main topic of this subject. So FinPro established 2 years back is a forum of professionals into the field of financial services and also into allied services. So all these professionals have come together and formed this forum to collaborate and also share knowledge and grow together. So as of now, we have a total of 82 permanent members part of FinPro, and there are 144 ordinary members. These members comes from various cities, right from Mumbai, Delhi, Chennai, and Kolkata, all four metro cities. Then cities in western region like Pune and Surat, Hyderabad, Bangalore, Baroda, Nagpur, Indore, Kochi, Pondicherry, and many more. And what kind of services are being provided by members in the FinPro group? So primarily, we talks about fundraising, which includes retail funding, business loans, SME loans, right up to large corporate funding, structure loans, acquisition funding, OTS funding, or allied services like services which can be provided by chartered accountants and company secretaries, advocates, credit insurance, IPO, business valuation, or even business process setups. With this, I will hand over, I will introduce you to our moderator of today's session, Mr. Ghanshyam Das Khandelwal. Ghanshyam, can you say hello?
Yeah, hi.
Yeah. So just to introduce you, Ghanshyam. Give me a second, sorry. So Ghanshyam is co-founder of a firm called Triage Advisors. It's a CFO services firm based out of Bangalore, and he has worked with many large family offices, EY, Goldman Sachs. He was a transactional banker earlier, and currently he operates from Luxembourg, Kolkata, Mumbai, Bangalore, and Delhi. Yeah, Ghanshyam, to you now to take charge of today's session.
Thank you, Sanjay ji. And welcome to all the participants today. So, and we've got a fantastic ensemble of panelists across key cities that they operate out of, and advocates and solicitors, and very well respected in their own professions, and have in collective, I would say, about 70-80 years of experience that they will be talking through today. For the next hour or so. So what we will do, just to give you a sense of the flow today, for good 45 minutes, we will be doing, Q&A, where we have put together a bunch of questions that we think would be very useful to ask on behalf of the wider participants attending today. And then we will move into more specifically if there are any specific questions that you may have, which you could ask through a chat or Q&A window that you see to the panelist. And I will just very quickly introduce the four panelists that we have today. Raj Gopalan Sripati. He's a senior partner at Legal Win Consulting, and he focuses primarily on M&A, startup funding, and company law. And Raj Gopal, if you could wave a hand so people know if you're there. Yeah, there you go. Super. And he's been, just to credentialize him further, he's supported on the acquisition of Myntra by Flipkart, which are both fantastic companies that you would know. He supported a couple of other acquisition by Shadowfax, another great company. And I happen to know the founders as well. They are in Bangalore. And then another company called Rapso by Inmobi. And then I think he's also on a couple of transactions in terms of fundraising, supported Blackbuck and a few others. And he practices out of High Court and have also made representations at National Company Law Tribunal at Hyderabad, Mumbai, and New Delhi. So very, very welcome, Rajgopalan, to have you here today, and really want to hear insights that you may have to give today. Next on the panel, we've got Sanjay Israni, again, advocate and solicitor with more than 20 years of experience, focusing more specifically on corporate and commercial laws, capital markets, and litigation. And I think some of his, what he would have to say today would be of fantastic relevance to this audience. He's a partner at Desai and Divanji. It's a very large firm, well known. And again, he's handled litigations before Bombay High Court, Securities Appellate Tribunal, National Company Law Tribunal, and all. And his focus areas are quite a few. He's sort of sector agnostic, so manufacturing, entertainment, hospitality, food processing, real estate, engineering, and I can go on. So again, I think he will be able to handle a lot of questions from a variety of sectors today if we get to that. Next on the line, and before we go to Dimple, onto you, Sanjay, if you can again wave your hand. There you go. No. Sanjay, yes. There you go, Sanjay. Next, we got Dimple Merchant. She's managing partner at Ivy Merchant & Co. Advocates and solicitors again, operating out of Mumbai. And she's acts as an advisor to major corporates, listed companies, real estate companies, banks, PSUs, FIIs, and she specializes in legal strategizing for money recovery, insolvency, commercial transactions, and real estate. And I would think I speak specifically money recovery, but I'm sure a lot of you would want to hear more of today. So welcome, Dimple. It would be easy to identify you, Dimple, but being the only female member, but still wave the hand, please. There you go. And last, but certainly not the least, my dear friend, Akshay Sapra. He's a partner at Ardent Legal, very dynamic, having worked with him on several situations. And actually, he will have some interesting insights, I'm very sure, because he seems to have advised more recently a buyers association very favorably to get a significant settlement compensation from a large real estate and on the back of a force majeure which was taken as a defense by the builder. So again, very, very relevant to be into this panel today. And again, he's advised on construction, logistics, pharma, agri and banking sector, has 10 years of very relevant experience in law. And again, I think his bedtime stories were probably case studies, considering his grandfather is a retired judge from Delhi High Court and now an arbitrator. And his father is a senior designated lawyer. So clearly would have a lot of advice to give when it comes to law. So welcome. And again, Akshay, if you could wave your hand, please. There you go. So we have all the four panelists, and I would just briefly give a few minutes or a few seconds of introduction to the topic just to set the tone. Clearly, we have many of you who are attending, very, very significant three-digit numbers in terms of participants. And clearly, we are all here today, considering what has happened in the last few weeks. Very unfortunate. Nobody could have ever imagined that not just a particular country, but the world going together through a collective trauma. and a pandemic, so to speak. It's something that we have only seen in movies, and it is live right now. So clearly, what we've seen in movies, we have not necessarily paid much attention to, though people are watching some of these movies more so now. But clearly, it has very, very deep implications when it comes to business contracts and contractual obligations at large, because it has thrown life out of gear. People have no way to be able to consider these times as business as usual. I would be very surprised if there is anybody in the audience who would have their business, or for that matter, their private lives to be considered normal as usual. Clearly not. And therefore, that said, I don't think life could stop. Right, we breathe, we eat, and we would want to do the general chores, and we would want to work. And clearly, when you would want to work, you will see some natural obstacles in terms of fulfilling your role as a counterparty to an agreement. And you would have a lot of those promises that were made in consideration of a business as usual environment do not stand anymore. And therefore, we are scrambling as a collective community, as a business community, to really understand what needs to be done and now what, and what do I do? I have this, when I look at my agreements, in some of those business agreements, I have this clause called force majeure. And I know that considering I've seen Reliance and few others, PVR Cinema, if you've read the news recently, going back and saying, that they want to invoke this force majeure, and you think that there is a ray of hope in terms of that particular clause helping you out when it comes to your business contracts. And if I take the dictionary meaning, and obviously I would expect the panelist to be talking a lot more, but all I could do as not being a lawyer is give a dictionary meaning. So I'll read it out for you guys. The dictionary meaning of force majeure is it's an unexpected and disruptive event that may operate to excuse a party from a contract. Right. So, and because now you cannot, in a certain situation, act of God scenario, fulfill your contract. Therefore, what are the implications of it? And that's what we are going to dive into the next 45 minutes or so. And then we'll hand over this back to the audience if you have any questions to ask. Yeah. Okay, I take that as a nod, considering I can't see my participants, and that sets the tone. So first question, Rajgopal, to you. And if you can just set the tone in a much more, lawyer-like fashion. What is force majeure? And if government has come up with any notification, any formal referencing to it, to the current pandemic, if that invokes force majeure automatically, or and again, who has the burden of proof to establish the force majeure event? If you can take the first question.
Good evening all. Thank you all for joining us, and thank you FinPro for giving us an opportunity. At the outset, let me tell, force majeure is a positive law. Force majeure is applicable in cases which otherwise would have tantamount to breach of contract. Force majeure is applicable in cases where parties are unable to perform the contract. If I were to put it in a simple layman terms, force majeure events include an act of God, natural disaster, war or warlike situation, labor unrest or strike, epidemics, pandemics, and change of law. To reiterate, force majeure is a positive law. It is covered under Contract Act, and Section 32 and 56 of Contract Act are the guiding laws for force majeure. Now, coming to the second part of the question, yes, somewhere on the first or second week of March, state governments of Maharashtra, state governments of Telangana, state government of Delhi invoked the Epidemic Act, which is an outdated law, but yes, it is still an applicable law, to restrain people and also advise people on social distancing and also advise closure of shops and establishment. As the severity of this epidemic transgressed from one state to another, the central government invoked National Disaster Management Act, by which the Central Act superseded all the state government acts. And central government, in order to give the lockdown a nationwide effect and also to invoke the force majeure clause, invoke this law under entry 29 of concurrent list. Remember, health is always a state subject. The central government can interfere if and only if the epidemic transgresses more than one state, and it should be a severely infectious state. Central government invoked this NDMA under entry 29 of concurrent list, which gives this epidemic a national disaster and also helps companies to look at the force majeure clauses that are applicable to them. Over to you.
Right,
Over
right.
to you, Ghanshyam.
Yeah. Okay. Okay. So just follow up on your point when you said some specific state names that you gave. So are you saying that not all, because all states have not come up with a notification or
See, you should understand the situation like this. The situation started somewhere in Delhi, some parts of India. Even today, if you were to look at this epidemic, it is spread to only 1/3 of the districts all over India. And not many states had invoked this epidemic disaster act. On March 22nd, the initial one-day lockdown was a perquisite. And on March 24th, when the Health Ministry invoked the NDME Act, it was a nationwide act. Because the reports from different states were trickling in. Whether to invoke such a major NDME Act, the government should have taken a lot of consideration. Of course, it has taken a lot of consideration. And that is when they invoked the NDME. And when they invoke the NDME Act, it is a total shutdown of all services. It is not an emergency, but it is a disaster applicable to infectious diseases. So, not many states were able to understand the dynamics, because even today, if you were to see the tracker, you will find more than 7 to 8 states with having 0 cases. I'm talking about 0 coronavirus patients. It's applicable only to some part of the state. But how do you stop people from moving from one state to another? How do you stop people from traveling? Unless until an NDMA Act is invoked, you cannot do all that. That is when the government on March 24th invoked the National Disaster Management Act, and that too under entry 29 of concurrent list. That is when the lockdown impacted the whole of India, all the 1.3 billion population, all the industries. Yes, sir.
Yeah, just want to add, that the Finance Ministry has come out with an internal official memorandum, which in fact mentions the entire COVID-19 as a natural calamity. But this is more for the internal department purposes, because it's an expenditure department official internal memorandum. So that's where this one piece, which is directly linked to the force majeure, has come in from the Finance Ministry.
Okay. Okay. So, that helps contextualize this. But back to you, Mr. Rajgopal. If you can give, I'm sure you have some live cases or examples to talk about. And, I would also ask a couple of you to supplement your own experiences just in recent last few weeks with your clients. But if you could give a couple of examples where, you might have supported a client to invoke force majeure, or one of your client may have been impacted because he got a notice or they got a notice, on force majeure clause. And what are the challenges and how the clients benefit? Like, how do you position this theoretical piece that we have just spoken about into what it means to the clients?
Let me talk about a company which provides maintenance, repair, and overhaul services for all aircrafts from various airports. One of my clients who is into this MRO service, that is maintenance, repair, overhaul service, his job is to maintain, repair, and service the aircraft and send it within a turnaround time of 36 hours. Now, between March 23rd, there were rumors of a lockdown. March 24th, Indian skies were being closed from March 24th. My client has its head office in Bangalore and the service at Hyderabad. Now, when the lockdown was announced, the aircraft spares were on the way from Bangalore to Hyderabad. No way it could reach. So my client invoked this force majeure because aircraft services, if you delay the flight, the penalties will run into millions.
Absolutely.
And moreover, the challenge is the aircraft has to leave the Indian skies on or before March 26, 00 hours, failing which the aircraft is getting standard here. These are all international airlines. So we had to invoke the force majeure clause and make the client accept the fact that it is our inability and it was impossible for us to move the spares from one state to another given the lockdown. And hence there was an involuntary delay from our side. We could not perform the contract because of the impossibility. Spares could not reach Hyderabad on time so that the aircraft could be serviced and leave Hyderabad on March 26. So we invoked this clause, client accepted it, and the aircraft flew on March 27th. We could save our clients huge amount of penalty. That is how, in my case, we were able to help the client. Otherwise, if the aircrafts are standard here, it's a huge international loss for the international airline. My client would have to pay millions of dollars. My client could escape the penalty only because of invoking the force majeure.
Okay. Okay. So just another question. It seems that this particular client acted quite fast. But I'm just assuming, and again, not being a lawyer, sorry if some of these questions are naive. But could this force majeure clause again be invoked? Right, it's ongoing. Anybody can invoke right now in the midst of this. It's not that you have to do it at the outset.
Can do it all through the lockdown period or post the lockdown period. It depends on the business circumstances which we all face at different points of time. Force majeure is not limited to the initiation of lockdown period. For example, L&T Metro, another client of mine, has to pay huge revenues to the state government. Today, they are not able to do it because the state government has lockdown. Now, lockdown is an act, non-payment of revenue is an act. Here we invoke L&T Metro, we have invoked the force majeure and told the government that we are unable to pay.
Okay. Okay. Good. Very useful. Akshay, do you want to add any of the live cases or examples you might have?
Yes, thank you. Good evening, everyone. One of the live cases which we encountered just 2 months back was with a client who was a housing society, a buyers association of that housing society, and they had filed a case against non-delivery of real estate against a big company, DLF Group, because as they were not able to deliver. One of the defenses which DLF, which was the respondent in this case, had taken was force majeure. They had pointed out very prominently that due to the licenses not being issued by the MCDs on the current piece of land they were having, which they were required to construct and deliver to this buyer association, they were not able to construct within the stipulated period of time. We, however, refuted the same thing, saying that these licenses which the MCD were to issue to DLF were in the acts which DLF itself had to complete. So the acts on which this circumstance was created is in direct correlation with the acts which the other party, which is trying to take the benefit out of this contract, was responsible for. So their plea under force majeure was rejected on this very point, that the benefit that they were taking under force majeure, it was an act of their own creation. So we were able to get a compensation for the home buyer association for the delay in this case. And this is a reported judgment in tribunals right now.
Okay.
So this
Very
was the
interesting.
example.
Good, good. I don't know, Dimple, would you want to add any of your? I'm just asking some of these because just to contextualize and see the wide, ambit that this particular clause has on various businesses.
So, hi Ghanshyam, thank you so much. Would just like to say that right now a lot of my clients have been asking continuous questions on the lease agreements and the leave and license agreements and the force majeure clause related to that, whether they can invoke it or not. To this, I'll just give a simple thing that your force majeure is actually, as Mr. Raj Gopal just said, is about impossibility to perform and not impracticability to perform. So if your leave and license agreements or your lease agreements have a force majeure clause, then probably you can invoke it. You can send a notice to them to invocation of force majeure. But it is, of course, if the clause is talking about a standstill, then probably the agreement will come in standstill looking at what the clause is. But if today you are already on the property, you are utilizing that property, then in that event, you cannot come to a point that a force majeure will be applicable in that case. Because one party's onerous obligation to perform is not to be used as a force majeure. So today, if I am occupying a property, then I have to pay a rent. So my liability to pay rent is not mitigated by a force majeure clause. So yes, there is that as a situation here. But however, on humanitarian grounds, some licensors, some lessors are agreeing to either cut the rent or to give them this 3 months or 2 months, whatever the lockdown period, as a rent-free amount, or probably they are deducting from their security deposit. So it is all going according to what the contract is or what an agreement is. But definitely, if you are not into, if you are using the premises, then you cannot say that it's a force majeure.
Okay, so this is I want to just debate on this for 2 more minutes, and maybe selfishly put you on spot, considering and take free advice right now, right here. So, I'm just, and this I think would apply to many of the participants today. So, I am in occupation of leased property, and I'm paying X amount of rent on a monthly basis. I saw somewhere, that force majeure could kick in. I read the clause, and with my simple reading, I could only see that if I have to invoke, it is on the both ends. So I may choose to, and please correct me, I just want a deeper understanding of this particular lease contract. If I stop paying rent, then equally the landlord or the lessor can also ask me to vacate, right? That's works two ways. And so if I think, I cannot pay rent because back to your point that it's impossible for me to get my staff and myself into the office under the current scenario, and I can't use it. But that itself, if I understood this correctly, is not good enough reason not to pay rent. And for me not to pay rent, I have to vacate the property, right?
So, to your question, I'll just like to simply say that merely you not entering your office does not mean you do not have the possession. So, you have the possession of your premises, so you are in a possession. Now, secondly, as I said earlier, today you have to pay your rents. The banks are working. So, it's not that you can say that there was an possibility for me to perform this contract because banks were shut. How do I pay? So that situation is not there for you. So when you are pleading that, unless and until you show that under section 108 of the Transfer of Property Act, that this property itself is in a condition which is irreversible, then in that event a force measure can be applicable. But whether this factor as COVID can be an irreversible factor or not, that definitely depends on case to case, and the courts have to decide that. But otherwise, in a normal scenario, since you're occupying a premise, it's like supposing you're saying is about your bank loans. Today, even if you have taken loans, you have to make the payments. Though the RBI has given moratorium of 3 months, but the payments have to be made. So it's not that even in lease agreements or license agreements, your rent has to be paid. It's not that you can't go away with the liability of not making payments. So non-payments cannot be termed as force majeure.
Okay, understood. But just to close out my personal story, I made a separate request as well, not invoking the force majeure, and he rejected it. So I'm not in a very happy place. But I think that would be the situation of many of people who have businesses to run out of rented
Right.
properties.
Right.
Good,
So
good.
it's on humanitarian ground. Maybe if the landlord and the lessor or the lessee, they have come to a common point, then it's a different case altogether, which I hope they somewhere look at the situation and come to a common point, depending on the contract.
Okay, so that's very good. So I think it's about appropriate and a good segue if we can just go into the minutiae a bit, and maybe Sanjayji, you can help out. What would be some of the key aspects that a recipient of the notice on the back of this particular clause has to consider, and what are the remedies available as a consequence of such notice?
Fantastic question, Gansham. See, the thing is that let's understand the situation. What stage are we? Stage one was the entire fallout of the virus in China, say a couple of months back. Then, presently, last 15 days, 20 days, we are in a lockdown as far as India is concerned and the entire world is concerned. The impact of the entire COVID fallout, whether it's India or the world, will be felt once the lockdown is over. So that time we'll be able to assess what is the impact on a particular business, on a particular operation of a company, etc., etc. As of now, basically, the impact can be assessed only from the stock markets or the commodity markets, oil, etc. But as far as the impact on individual businesses is concerned, will only happen once things open up, once we are out of the lockdown, and once we are back to our offices. So once that situation arises, there will be a lot of situation where a lot of these force majeure notices will be sent, a lot of disputes will emerge. There will be a lot of counter strategies as far as how to counter a force majeure situation. So it's important to firstly understand, to assess this rightly. Firstly, we have to first see what the contract is all about, the entire nature of the contract, and then look at the force majeure clause. If the force majeure clause somewhere is provides for mitigation of the entire risk, so you have to first consider whether have you tried to mitigate the risk if it is possible. Secondly, if the force majeure clause provides for suspension of performance, and basically we all are in basically suspended animation mode. So whether particular agreement has stand suspended for this duration of the force majeure, then everything gets suspended. Maybe 15 days, 1 month, 2 months down the line, everything will be back. So it all depends how the clause is framed. How tight it is, what kind of degree it has, whether it's a high degree clause where there is no mitigation, no suspension. The only option is to kind of invoke the clause and invoke this right as far as the agreement is concerned. So that's one part of it. As far as your force majeure notice is concerned, which you'll have to kind of send to the other side, you'll have to actually set out the entire impact of this happening on you, on your business, and establish that force majeure, establish that the event has really kind of has an impact on your operation, your business, your financial condition, etc., etc. On the remedial side, the other side will have to assist it. He will have to establish that somewhere there have been government facilities or relaxations as far as your particular sector business is concerned. But I'm quite sure the government will come out with various relaxations for the real estate sector, infra sector, almost every sector, the textile sector, whatever name you call it. So there are going to be relaxations from the government as far as compliances are concerned, as far as reliefs are concerned. There may be a tax rebate, there will be a GST rebate, etc., etc. So all these situations, all these circumstances will have to be considered before a force majeure notice is actually issued. And secondly, how the force majeure notice is actually defended. For example, if it's not a genuine case of force majeure and it is only used as an excuse to get out of a bad bargain, then in that case, the other side may file a suit for specific performance in a court of law and seek an order against you to actually perform the contract. Or in case there's an arbitration clause in the agreement, arbitration may be invoked, and arbitrator may be appointed under Section 11. Section 9, make an application under Section 9 where an injunction order can be passed against you from whatever kind of relief depending on the facts of the case. And you can also kind of create a specific performance before the arbitrator once the arbitration proceedings are initiated. So there are various things on both the sides.
Yeah, you make a very good point, that this situation should not be used as an excuse to not perform. Can you give maybe one example between what would classify an excuse versus, real?
Yeah, for example, say there's a manufacturing unit which provides essential services, which is part of the entire essential services which are exempt from this entire lockdown and stuff. And somewhere this particular entity is invoking force majeure, just to get out of a contract. But somewhere he fails to forget or fails to realize that he's a part of the essential services. Maybe his operations are on, he's able to supply goods, etc., etc. So that will go against him in case a litigation is initiated against him. So these kind of facts needs to be kind of you first need to sensitize your facts, because force majeure is very fact sensitive. It is going to be completely based on the facts of the circumstances individually and all around.
Understood. Okay. So on the flip side, if what would be similarly the aspects that the person or the party making a claim would have to consider?
See, it's all fact based. Firstly, your internal facts of what kind of impact you had in this entire lockdown period or post lockdown period, when you actually realize the impact, or when the impact hits you. So this situation, and is there any scope for mitigation, whether you've taken steps for mitigation? That's important, because you'll have to the other side is going to take a stand whether if there is a provision for mitigation in the force majeure clause. So have you in fact complied with that requirement?
Good. Akshay, would you want to add something to that?
Yes. So as far as people who are receiving notices in which their counterparties have actually applied force majeure clause, whether it be in terms of rent or anything else, they just need to check three particular things in their agreements. First is they need to check whether the agreement has a contract of force majeure in which they can claim benefit out of. If there is no force majeure clause, then they also have to consider whether the agreement is frustrated or the contract is entirely become the performance of the contract is become impossible due to that particular force majeure event. The second thing is, once they establish that they have a clause in the agreement, the second thing is, are the circumstances which constitute a force majeure being created by the party who's taking benefit out of this clause? This is a very important point in this particular case. The example which I took of DLF case, they were actually making use of force majeure clause to their own advantage out of the circumstances which they themselves created out of that. So it becomes very important for the person to ponder over this point, whether the circumstances are being created by the party who is benefiting out of this force majeure clause. And thirdly, if the answer to this point is also no, then the party should also understand whether there was appropriate due diligence or whether the risk could have been mitigated by the party who's claiming benefit under this contract. So three basic conditions which could be checked by anyone who's receiving who's at the receiving end of this force majeure clause.
Mm. So you speak of this doctrine of frustration. Many moons back, this is one of the contract laws that we read while doing our chartered accountancy. But there is this doctrine of frustration that you refer to. So there is a possibility that many of these contracts are ill-designed or are not comprehensive enough to capture force majeure clause. And then, what is the remedy available to the parties in such scenarios?
So, doctor, even for an ill-designed contract, if you specifically talk about doctrine of frustration, which is impossibility of the contract itself being performed in these situations, the Contract Act itself provides for this stipulation to be there. So it does not need to be mentioned specifically in the contract itself. Section 56 of the Contract Act itself states whether upon a circumstances where a contract is impossible to perform, it becomes frustrated and hence becomes void.
Mm-hmm. So I think this is I just want to stress, for the part of the audience who might be looking at their phones, is that even if you do not have the explicit clause mentioned in the contract, you still can leverage, advocates, solicitors, and legal help to see what remedies are available to you. So it's, everything is not over just because you don't have that clause, right?
Correct. Specifically talking about doctrine of frustration, which is provided under the Indian Contract Act.
Good. Dimple, this one could be for you. So I think now we have a sense of, that the performance of the obligation could be excused in such scenarios. But if I have to take this one step further, could, the parties also get compensation, as well?
Well, no, actually, if there is a force majeure clause already invoked and there is a genuine force majeure, then compensation is not something which the parties will get. However, if supposing the parties have actually used this force majeure, and as Akshay also said, and as Sanjay also said, if they have not mitigated the loss or they have not shown that they could have performed the contract, but they have failed to perform the contract by just simply using this as COVID or lockdown as one of the reasons, then definitely they can call for damages or they can ask for compensation if this was just a way to escape from complying with contractual obligations as per the contract. So yes, definitely. Secondly, there have been various judgments also which suggest that if there is a variable component on which your contract is applicable, and in that event, if there is supposing an increase in the prices or falling prices, then in that event, the circumstances have to be looked into, and then accordingly, whether compensation is to be levied or whether it was genuinely a force majeure, that has to be looked on case-to-case basis. So yes, definitely a compensation if force majeure is genuine, then will not be given. But if force majeure is used for the sake to run away from the contractual obligation or take a pause from it rather, then definitely a party can claim compensation and damages. Aggrieved party can.
Yeah. It sounds, thus far to me, is that it is very factual, fact-based. And, so a lot of this may come down to evidencing, right? And
right.
So
Absolutely.
clearly, I think for the starters, you may want to create that trail and audit trail, if you will, of evidences, so that you are in a good place when it goes into any kind of litigation, right?
Also, I just want to add from what you said is if you're invoking a force majeure notice, then in my opinion, it should be that you have to give the details of how this is a force majeure applicable to you. Because tomorrow, if this goes into the litigation, then your notice of invoking force majeure is very important. And whether have you substantiated enough the reasons for invocation of force majeure. So those circumstances have to be quite elaborated in your notice. Simply, you cannot say that I'm invoking a force majeure under so-and-so clause. So that is important because that might be a circumstantial evidence also, including the notifications and all that governed by the government from time to time.
Okay, good. I think we are reaching to our time, and I get a sense that we have a lot of questions being asked. But I think I'll leverage my position as a moderator to ask one more selfish question. And while selfish, I think it again would impact a lot of participants. And a lot of us have employees, right? And but clearly these are stressed situations, and we don't necessarily have the cash flows coming in, and the business obviously for many of the business owners would go down by, I don't know, X percentage, and you would want to still, you are not running a church and charity, so you would still want to run a profitable ship and cut your cost or optimize your cost, if that's the right word. And we have heard some announcements ourselves that some of the big fours and some of the organizations have proposed, deep cuts to the salaries of employees. And my sense is, while this may not, and it's slightly off topic as well, but still I would think very relevant. It may not directly be, and I have not seen in any of the employment contracts in past, having worked with some of the organizations, any such force majeure clause, because it's more specific to business contracts. But, obviously there is an employee contract between the employer and the employee. And could the employer go back and ask its employees that I would be making a certain cut to your salaries hereafter? And would such cuts also be more permanent and perpetuity oriented, or would it be temporary in time considering the scenario, and when the markets open up and things are hunky-dory, they are reset back to the levels that were? So if you have any cursory advice on that, how to approach a scenario like this?
Ideally, first and foremost, termination of an employment or of migrant workers or laborers do not form a part of force majeure. They are two separate things altogether. Your employment agreements may or may not have a force majeure point. If it may have a force majeure point, which 99% of agreements don't, but if they have, then the point might be on reduction of salary. This might generally be in case of KMPs, your key managerial persons, or those of the higher on a higher grades. However, in case of reduction of salaries or termination, that is completely between employer and employee. However, there are directives that are issued by the government from time to time to keep them on their payrolls and not to terminate their salaries. So obviously, from this we can gauge that you can speak to your employees, and if they are in a financial situation, probably you can reduce their salary, speak to them, and keep this as a stopgap arrangement. You can right now mitigate your losses, also reduce your losses by giving them half salary, and later on you can recover as and when the markets improve and the conditions improve. But you cannot definitely use force majeure as a clause for not payment of their salaries. That's not the idea of force majeure.
Got it. So maybe one last question. Sorry, I didn't anticipate this one. Maybe one last question. Obviously, and again, my sense is that this was one of the clauses that people would just accept as one another clause. And maybe in your bilateral agreements, you may not have paid a lot of considerations in past onto this, particular clause. But do you think now a more premium would be placed to ensure that this particular clause of force majeure is well negotiated? Maybe Akshay or Sanjay, if you want to address this particular question.
Yes. So in terms of the applicability of the force majeure being used, it has been widely used in contracts since the Contract Act began. And it has been deliberately left out of certain contracts because of a number of reasons. But in terms of where time is of the essence, a lot of companies use force majeure clauses in order to avoid penalties, big penalties, which is there, which essentially means that you can only defer these circumstances up till the force majeure period ends, and you later have to fulfill them in those cases anyways.
Sanjay, anything you want to add?
Yeah, I think going forward, the FN clause will get more complicated, more sophisticated. There'll be new, ideas which will be incorporated in the entire force majeure clause. I guess there'll be threshold limits which will be kind of incorporated or imbibed in the entire clause. For example, for a hotel industry, for the civil aviation industry, you may have a clause saying that okay, if 25% of cancellations happen, it will lead to force majeure or something like that. Even risk mitigation clauses may increase. There'll be various alternatives that will be provided in the clause itself. For example, in case A happens, you have to do B. B happens, you have to do C. There'll be various alternatives which may be carved into this clause. So, as far as going forward is concerned, there'll be a lot of sophistication in the clause itself. It was a very standard boilerplate clause as far as we are concerned, we lawyers are concerned in the past, but now I'm sure we'll have to put in some time to it.
Good. Okay. I get a prompt that we have more time, so I'll probably ask a few more questions before I open up for Q&A. So back to you, Dimple. So can people use this while having I just want to go back because it seems it's very crucial on the ability to perform kind of a scenario. Can you who has the ability to perform and wants to just walk away from the contract and on the back saying that this contract is one-sided, is that possible?
No, it's not possible. But yeah, there might be parties who might want to do this to get leverage out of the situation. But again, as all our panelists have said time and again, this is very circumstantial and depends on the evidence. So you have to prove that this force majeure was genuine. Firstly, not at the circumstances, but whether he or she could complete the agreement or not, perform the contract. So say, for example, you have many companies who are doing work from home. All right. So in that scenario, you cannot come and say that there's a contract and because of the lockdown, offices were shut, I could not complete the contract. Whereas the situation in that particular contract might be that the person can complete sitting at home. May not be a supplier contract, may just probably be another service contract. So it really depends on each and every contract, what it is, and depends on the situation and circumstances. But definitely you cannot take a plea of being one-sided contract, because at the end of it, you have to prove the person who's urging it to be a one-sided contract, or the person who's speaking of a force majeure has to prove whether it was actually a one-sided contract, which is definitely not something which is similar to a force majeure, because they are two separate things altogether, being one-sided and a force majeure. So these two things are very different. If he is going by the force majeure, then the proving of force majeure has to first come in play on what basis this is a force majeure, what he or she has done to mitigate the loss, like how Mr. Rajgopal's clients had done everything possible to mitigate the loss. Even Akshay's clients had done, and where the compensation the other side had to pay because they misused the force majeure clause. So yes, it will definitely, this kind of arrangement or this kind of thought process, if somebody has to misuse the force majeure clause, will definitely open floodgates of litigation, and that's where probably we'll come into picture.
So then it would be safe to assume that if a supplier has already delivered goods to the buyer, the buyer would not be able to deny or delay the payment. Is delay possible?
No, the buyer has to make the payment. A force majeure clause does not cover a contractual liability to pay if the part performance of the contract is already taken care of. So today, if he has already purchased or he has already got the goods in his possession, he is bound to make the payment. He cannot use the force majeure clause to avoid making payments. So yes, definitely
Even
he has
on the
to
back
make.
of cash flow issues, and he can't cite that I'm not.
Irrespective,
Okay.
irrespective of that, he has to make the payment. Probably, if the buyer and the seller both, because see, one thing is that the banks are working. All right. If today I understand the scenario that the banks are not working completely, or there is complete lockdown where there is no way you can send the money or anything, then it can be a possible situation. But when the banks are working with whatever limited access or whatever it is working, then in that event you cannot deny or is a liability to make the payment.
Okay. Good. Uh, Sanjay, any views from you on and again, I think I am asking some of the questions which came on the back of registration as well. When people were registering for this event, and somebody asked, what do you think could be the impact on real estate and construction, considering your own experience having dealings with these clients? What do you think about this? How will this evolve?
Well, real estate is $1 million question as far as this entire COVID-19 is concerned, because we've already seen the impact on the stock markets, the commodity markets, etc., forex markets and stuff. But as everybody knows, we are in a lockdown situation as of now. Once the lockdown is over, business get back to the normal scenario. The impact will be felt at that point in time. And real estate is a very very ground situation reality. We don't have a market which kind of speculates on the price of a real estate, etc. So real estate is going to be very ground based, very fact based, and very impact based as far as this situation is concerned. In fact, I go back to the year 2008 when the financial crisis struck the world. Though it was more US kind of impact, but the entire world felt the impact because a lot of the FDI investment in real estate had taken a hit because of the financial system collapse in US. So as far as COVID is concerned, of course, it is maybe 10 times more than the financial crisis of 2008. And it's going to be a developing situation. We'll have to see what really happens. Real estate is a very sensitive sector as far as India is concerned. In fact, every individual is affected because of real estate, because the kind of importance real estate has to Indian lives. So it all has to be kind of, we'll have to see. It's a very developing kind of a scenario. And hopefully nothing much happened post 2008 as far as real estate is concerned specifically in India. But you never know. It may be a different scenario this time.
Well, we'll see how it pans out. Well, I'll just take a pause here, and we will shift gears and move into Q&A. But before I do that, I would like to just invite Suresh Nair to speak, a few words on behalf of FinPro.
Thank you, Ghanshyam, and good evening to all the participants. It's been a great evening where over 120 people are live, in the audience. And this is one of the initiatives that FinPro, as a financial professional body, has been engaging over the last 2-3 years, where we meet across the country, trying to leverage the best of talent across the country with diverse experience that can affect finance, legal, and various other factors that can impact the business. So that our clients and our... Is it?
So can you just check your... Please. Hello.
Yeah. So over the last 2 years, it's been our endeavor to move across the country and work with professionals from diverse fields. As Sanjay already said, that we already address very diverse services, which ranges to almost 30 plus services across the country. And this is an opportunity for all finance professionals and allied professionals to be part of FinPro, which is growing across cities. And I would take this opportunity to connect with all the finance professionals who are attending this session right now to connect with us after the event is over, so that we can look and add value to each other and the community at large across the country. Thank you very much, Ghanshyam, for giving me this window to speak to our guests. Thank you very much.
Thank you, Suresh. Okay, with that, we'll come back to the questions that has been asked on the Q&A, by the participants. The first one, and I'll just read it loud. I'm not too sure if some of these questions have been asked, and if have already been asked, I will avoid repeating the question. Can force majeure clause only, and again, let's try to take as many questions, and if I could ask the panelists to be a little bit more succinct and pointed in their responses. Can force majeure clause only be invoked while the restriction lockdown period is on, or even after the lockdown is lifted, as business may face difficulties later after returning to work due to low consumer demand? Yes, no? If you want to answer that one. You're on mute.
Yeah, force majeure is applicable at the time of initiation of lockdown, presently and post lockdown. But individual circumstances will vary. The impossibility of performance has to be proven, has to be demonstrated and proven by the character and conduct of the party. Now, assuming you are a manufacturer, and because of the lockdown, your machine retooling period is going to take 15 days time. And because of this post-lockdown scenario, you are going to take, instead of 15 days, 21 days time. You got to demonstrate that post-lockdown, despite your best of the efforts, you are not able to deliver on time. So the answer is the force majeure clause is applicable at all points. Initiation of lockdown, present during existence of the lockdown, and post-lockdown. But however, the character and conduct of the party should be that he did his best efforts and did all his, he exercised all his due diligence to perform the contract.
Okay. Before I take the next one, can I ask all the attendees, there are already 10, 12, 13 questions. So if you can go through the questions, and if you think those questions are the questions you also have, you can click on the like button that you would see under the question. And then I would like to seek answers to the questions that has maximum number of likes, if that makes sense. Super. I'm already seeing, questions being liked. So we'll wait for 5 seconds and see which one pops up at the top with maximum likes. In the meantime, I'll try to address the next one. Force majeure and doctrine of frustration are the same. I would think no. Is that the right answer?
Yes. If I may take this question. Has been taken by almost every panelist here, but yes, in order to repeat again, force majeure is different from doctrine of frustration. Doctrine of frustration, when the contract becomes impossible to perform, and force majeure is only for a limited period, so that both the parties attain the normalcy which they had at the time of execution of the contract. The circumstances come to the same.
In fact, there is a Supreme Court judgment, Electricity Watchdog versus the Central Electricity Regulatory Commission, CERC, where Supreme Court has very specifically stated that where you have a force majeure clause, doctrine of frustration will not be applicable. So that is very clear.
Okay, good. The next question with 5 likes. In some 6 likes, how does it affect someone who has rented out a retail space?
I would like to answer this. I think I've already said it before. If you have already rented out your retail place and they are already in possession, as I had said before, then you can definitely claim from them the lease rent for it. However, the modus operandi, it might be subject to what your agreement is. If your agreement has a force majeure clause and that's been invoked, then it's up to you whether you want to accept it, because they're already working on your premise. The possession is already given. Uh, so this is a very circumstantial thing. However, as I said earlier, since the person is in possession, you can definitely claim lease rent. There cannot be a force majeure because the property is being used, irrespective of whether you're working on it or not. Unless and until the lessee or the licensee has terminated this agreement, in that event, then the scenario becomes different. But they have not terminated, then you can definitely look at this circumstance also.
Okay. So hope that answers Bhavesh. Yeah, sorry, go on.
Well, see, a leave and license agreement, a lease agreement comes under transfer of property act. Now, assuming I am in a rented premises, technically I am in possession of the premises. Now, when building is destroyed, I can take umbrage under force majeure. Just because the building is not being used by me because of the lockdown doesn't mean that I cannot pay the rent. However, you can enter into a contract of forbearance or renegotiation with your landlord, but don't use force majeure clause for that. You can use business environment for that. Force majeure doesn't support non-payment of rents.
Okay, great. Thank you. The next question with maximum likes from Vishal Vadwa. In some of the areas, state as well as central government ask owners of organization to provide full salary, not charges rentals, but most of the cases, private owners did not comply on the same. Then in this case, what is the remedy available with the tenants and laborers? Who wants to take that?
This I had answered earlier. So to this question, I would just like to simply say that force majeure, again, I'll be repeating, force majeure does not come in place when it comes into the employer and employee relationship. You will have to pay salaries to them. If you are in a difficult situation, then probably you and the employee can probably sit and discuss or probably reduce their salary or do their pay cuts. It really depends upon your financial situation, because directives have been issued by the government not to terminate anyone's employment or not to put them in jeopardy. So accordingly, you can find a midway out by reducing their salaries. Again, with the rent issue, which is there, as we spoke earlier in our earlier question also, rent, it cannot, avoidance of rent cannot be a force majeure. Again, avoidance of non-payment of money for some contractual obligation cannot be termed as a force majeure. So you will have to pay the rents, you will have to pay your outstanding amounts which are there, that you cannot run away with.
Okay.
I hope that's...
Yes, it does. And I thought this was answered as well.
You can ask for a deferment.
Yes, definitely.
You can ask for a deferment, you can ask for moderation from security deposit, but you cannot escape from it. That's what we are saying.
Yeah, so you still have to pay.
The only risk that you will run is that, if you're running against or going against the government directive, there may be an issue as far as certain complaints to the government as far as your actions are concerned. So that may again go against you in case you take these kind of actions. So then you have to basically check the facts, see what pays, and then take your actions.
See, look at this way. On one hand, businesses, they are looking at their cash flow and refraining from paying rents. Other hand, the post-lockdown scenario it's going to be a pot-boiler scenario where there is going to be a lot of changes. A landlord will not have a better tenant than any one of us in future. So for him, living with us is better than venturing out into the unforeseen. So landlords will also apply. So we don't need to have any apprehension. And let me tell you, if some landlord goes to the civil court and asks for eviction, I'm sure courts being humanitarian in nature will not forcibly evict you out. So all I will suggest is enter into a contract, negotiate with your landlord, don't run away, and defer your rental agreement. For example, A couple of clients of mine have paid only 20% maintenance charges. A couple of my clients have told the landlord, we are unable to pay because of our cash flow. Kindly bear with us. Landlord, with a little bit of pinch of salt, they have accepted. So we got to go and approach the landlord and make them accept that the cash flow is tight,
Okay.
and the shutdown is, because of the shutdown, our cash flow is tight. All we have to do is that.
Okay. Thank you. That's helpful. The next
Also,
one.
1 minute, Ghanshyam, I just want to
Sure.
speak on this. One more thing is that today, if you terminate your employments with your employees or your laborers, then tomorrow you cannot come and say that I cannot perform the contract because my laborers are not there, or because of the lockdown, my laborers have moved out of the city, or they have not come, and there is a labor issue happening in my organization. Because day in day out the government has given directives that do not terminate their employment. So tomorrow, if you're talking about using this as an situation in a force majeure for some other contractual obligation, then that also as a circumstantial evidence, you terminating their employment and they moving out will also not help you in that contract. So you have to gauge your situations and scenarios carefully and decide upon.
Sure. Okay, great. And while we are asking questions, we are trying to cover almost all of these. But if some of these are unanswered, can I ask one of the FinPro members to just put in the email IDs so that any of the participants could reach out if they have any subsequent further questions as well. Yeah. Okay, the next one. What if there is no force majeure clause in the contract agreement? I think Akshay answered that particular question. So there is still remedy available if the force majeure clause is not there in the contract agreement. So we'll consider that answered. The next one with 4 likes. What when many IT companies have shut their offices due to lockdown, but majority of the employees are doing work from home? In this case, force majeure can be applicable to them. I think we are talking about a relationship between the employer and employee, and I think Dimple answered that question as well. It does not apply, and it's a separate employee contract, and it has to be considered on its own merits separately. So this particular clause does not apply, right, Dimple? Okay, so I'll consider that answered as well.
And
next one.
One more thing, sorry. So the only thing I would like to say is that if your employees are working from home, you cannot say a force majeure clause, because whether they are coming to your office or not, the work is being done. So that definitely cannot be called as force majeure.
Okay. What if there is no? Okay, that's done. I will move that away. This is done. Vikash Khandelwal asked another question: whether contractor is liable to pay wages to the manpower deployed at the principal employer's site, as they are using force majeure clause to terminate contract to avoid payment to manpower.
Principal employer cannot terminate the contract. His question was, principal employer has terminated the contractor. The contractor has the right to sue the principal employer, number 1. Number 2, the contractor cannot stop payments to his employees. That is the answer.
Okay, super. Hope that answers Vikas. We have
notices to the principal employer. Yeah.
Yeah, that was the question. Yes, we have challenged. We have challenged refund money to customers, money which is with airline and hotel that they give. Okay, so it seems the question is that they have booked tickets and the money is gone to the airlines and hotels, but they have not refunded the money, rather given credit note. So the question is a very good one.
Has he done it through travel portal? Travel portal or the airline direct?
So let's consider both the scenarios.
If it is a travel portal, the travel portal has to return the money. If it is a airline, where the flight and the ticket is booked together, flight and the hotel is booked together, the credit note is the acceptable thing today. Should he wish to exchange the credit note, we should contact the airline directly. Force majeure cannot apply in this present case.
Just to add to that particular question, Ghanshyam, a useful tip, if anyone is making travel or flight accommodations during this time, and it is through a third party, specifically like Make My Trip, Yatra and all, and if you're paying by credit card specifically, you can simply call up your bank and ask them to refund the transaction. They'll get in touch with the third party provider and cancel the contract. It's just a helpful tip.
Yeah, okay, thank you. This question again, can force majeure be invoked in a situation where there is no explicit clause in the agreement? It's getting repeated again. I don't know, Akshay, if you want to answer this one more time. But let me shorten this and say yes, there is remedy despite the fact if the explicit clause is not there. So go on.
Just one second. Sorry, Ghanshyam. So if the force majeure clause is not there in the contract, it cannot be implemented. The reason why, the only specific exception is the doctrine of frustration. When the contract itself becomes impossible to perform. I'll take an example since it's been coming up. So let's say a vendor has to supply some material to a particular buyer in a span of 2 months, in which this which constitutes this 2 months. So and there is no force majeure clause whatsoever in the contract itself. The buyer, if in this particular case, what will happen is that since there is no force majeure clause, then also the benefit of the doctrine of frustration will be available. Simply has to say. So if there is no force majeure clause in the contract, there would be, you cannot take benefit out of this. Otherwise, we would have done it for lease agreements, for employee agreements. But if only one exception is there, that if which is stipulated in the Contract Act, if the contract becomes impossible to perform, then you can take this benefit. That's it. And that's a different stipulation. Let's not mix force majeure and doctrine of stipulation. Doctrine of frustration, sorry.
Okay, super. Maybe it looks like we still got a lot of questions and we are well over time, but maybe I'll ask one last question and then, hand it back to Vijayji. This is, so Rajesh Shah is asking a question, owner of Auriga Corporate Advisors, whether mandate period will be excluded from the lockdown period and beyond. Contract cannot be completed and mandate fees can be demanded. Mandate has force majeure clause.
I think he's talking about the mandate for sourcing of funds or some fundraising activity. The mandate by default will be extended.
Yeah, not very clear. Not very clear.
If it is a mandate for fundraising that he has got from a client and the fundraising is from a venture capitalist or the bank, the mandate by default will get extended. The client cannot withdraw the mandate because of non-performance.
Okay, super. So again, another prompt for us to stop. But look, thank you to all the panelists. I think this has been, brilliant discussion, and I could not have half hoped to get the answers to so many questions as we did today. So full credit to all the panelists, and thank you for your time and indulgence. And I will hand it back to Vijay Agarwal.
Thank you so much.
Thank you.
Thank you.
Thank you.
Can I invite Mr. Vijay Agrawal to say a word of thanks to the panelists and to the moderator?
Yeah.
Mr. Vijay Agrawal?
Yeah. Can you just start the video?
Yes, Vijay.
Yeah. Thank you, everyone. First of all, good evening to all. What a lovely session today. I'm sure everyone who was there as a participant have got benefited with today's session. And I'm definitely like to thanks all our four panelists, starting from Rajgopalanji, Dimple Merchant, Akshay, and Sanjay Insarani. I'm sure most of the question they have tried to answer, and they have tried to answer in a very, very detailed way. And with this, I would also like to tell the participant that whatever more queries they are having regarding the force measure, they can always write to us on the email ID given in the chat. And with this, I would also like to thanks the team who were giving the support like anything from the day we have started to devise this thing. So I would like to thanks Rajan Gadaji, Ritesh Jain, then yeah, Rajan ji is there in the then Ritesh Jain. Then I would like to thanks Urvin, then Manish Hegde, and Mrityunjay Gupta. So these were the people who were behind this thing, managing all the complete show. Over to Sanjay Vindarji. Thank you.
Yeah, thank you very much, Vijay. So it was a wonderful show, and with this session, we also promise to come out with more such interesting session in time to come. One more very
Yes,
interesting
yes,
and a very general, not this was very technical session, frankly. And as in college
right.
days, like जब बोलते थे कि बहुत कुछ ऊपर से जा रहा है तो वैसा हो रहा था. So, but next session will be for the business owners, and the details will be announced soon.
Right.
So please remain in touch,
Right.
and we look forward to meet you all. Last but not the least, FinPro is a platform wherein we are able to collaborate, and we request all the finance related professionals or allied service related professionals, please get in touch with us. You can also be part of this platform. It's open for all the professionals, and lot of positive energy, lot of knowledge sharing, and lot of business is happening together. You can be part of the success journey, what 82 people are already doing and will continue to do so. So please, you can get in touch with the email ID, which is shared on the chat box here. You can write a mail there or get in touch with any FinPro member you know, and we will take your application forward. Thank you all. Thanks for all your cooperation.
Thank you.
Thank you. Thank you.
Thank you. Bye.
Thank you.
Thank you.
Thank you.